Good afternoon, everyone. It's my great pleasure to bring in front of our students Atteeyah Hollie, who is the directing lawyer for impact litigation at the Southern Center for Human Rights. Based in Atlanta, the Southern Center is one of the nation's leading public interest law organizations. It was originally called the Southern Prisoners Defense Committee, and it has now moved into its fifth decade. And it is a terrific and stable organization that has had enough successes in, it does both civil and criminal cases, but it's had enough success in its impact litigations that it actually owns its own building, which is unusual for a public interest organization. Atteeyah is a California native. She grew up in the Bay Area, went to high school in San Francisco, then went east to college at Dartmouth in New Hampshire. And shortly after graduating, she had her first foray at the Southern Center working as an investigator, doing a number of things. And for those of you who have not yet been in practice, the role of investigators is very important in civil and criminal cases. And one of the most astonishing things I think about Atteeyah's stint as an investigator was discovering someone who was in prison whose sentence had actually ended, but no one had bothered to tell him or to release him. It was truly an astonishing thing. She then went back to California for 3 years to go to law school at Berkeley, and then came back to the Southern Center a decade ago and has worked on a variety of civil and criminal matters. And now, like most of you, she is spending most of her time working from home. So among other things today, besides her casework, you'll get to hear a little bit about what it's like to try and be a lawyer working on Zoom or other mediums of that type. And with that, I'll just say, Atteeyah, welcome. The floor is yours.
Thank you so much for that really kind intro. I really appreciate it. And really welcome to you all. I remember these types of lunchtime talks from when I was in law school. And I assume that you guys are remote right now. Is that right? Okay. Yeah. And so I know that you are missing really lavish lunchtime meals and stuff that accompany these talks. And so I hope that I can make up for the dearth of really good food with my remarks. But yes, my name is Atteeyah Hollie, and I am recently appointed Managing Attorney of the Impact Litigation Unit at the Southern Center for Human Rights. And I'll spend my remarks really talking about, the overall work of the Southern Center, as well as my role in doing impact litigation within the office. And then I'll spend a little bit of time talking about our internship program and hoping that you guys can join us sometime in the future. So I'm going to go ahead and share my screen, and it's my understanding that that folks can put questions into the chat throughout my presentation, and so I really hope that folks do that. I know that this kind of format really lends itself, or really sides on the side of it being more of a lecture, but I'm really hoping that we can make this as interactive as possible. So I'm going to go ahead and share my screen. Just give me a second. I have a dreaded PowerPoint, but I'm hoping that it will be interesting. And so, I like to call this talk, the color of justice, because I think that so often the way that people are treated within the criminal legal system, within jails and prisons, is often defined by people's race, hence my title. And so just one quick note about the Southern Center for Human Rights. We are a nonprofit law office based in Atlanta, Georgia, that is really committed to bringing fairness and equality to the criminal courts, jails, and prisons of Georgia and Alabama specifically. And we do this work in a number of different ways. One is that we represent people who are facing execution in both of those states. And we do that across the procedural timeline. For the most part, we represent people in appeals and post-conviction proceedings, which means after they've been convicted. But we have a couple of clients who have not been tried yet and who are in the pretrial phase of their cases. And we also do a range of impact litigation, which I'll talk about in a second, and I'll define what that means to bring impact litigation. But we also have a small but mighty and growing arm of our office that does public policy work, working at both the state and local levels in Georgia to advance ordinances and law changes and such that will benefit the people we serve, and to fight off, unfortunately, very, much more often fighting off really bad laws that only stand to deepen racial and class inequality within our criminal legal system. And so those are kind of the three facets of our office at the Southern Center. As I mentioned, though, as I started, in thinking about the color of justice, I'll be remiss if I didn't kind of, show you a few stats that kind of drive the work that we do at the Southern Center. As I'm sure is no surprise to anyone who is in this meeting, the color of one's skin largely dictates how they will be treated within our criminal courts, and really dictates whether people even have an initial interaction with police officers to begin with in the community. And so it's no surprise, or it shouldn't come as a surprise, that Black people, specifically Black men, are far more likely to be stopped, arrested, and charged with a crime than their white counterparts, that white people have a far greater likelihood of receiving a sentence that doesn't involve incarceration versus a Black person who has a similar crime for which they've been charged. And that even on the far end, on the back end, when we're looking at parole decisions and such, that whites have a greater chance of being paroled than Blacks are. And so this is the backdrop against which we do the work at the Southern Center. But obviously, I want to make clear these are not statistics that are unique to Georgia, right? These are not statistics that are unique to Alabama. It is a national phenomenon that race often drives outcomes within our criminal courts. But I just want to give you a sense of where we're at and how we do this work. And then there's the incarceration rates, right? I'm sure that it's well known to everybody that the United States is one of the leaders in the world, one of the leading wardens in the world. But when you break it down state by state in the United States, if we were to treat every state in the United States as a country, the vast majority of those states would surpass incarceration rates of entire nations in the country or in the world. And what this graph is showing you right here is basically comparing the incarceration rate of Georgia to other country or to countries across the world, including the United States. And as I think you can see here, the rate of incarceration far surpasses that in the United States and is just exponentially higher than other countries, or rather of countries across the globe. And so, I should have pulled up a map that really breaks down state by state so you can see how Oklahoma, Louisiana, Mississippi, Alabama, other states that are in the South compare. But what you would see, and I encourage folks to really look this up, is that the Southern states are really leading the country and accordingly leading the world in the rate of incarcerations, in the globe. And that is, again, another of the factors that really drive our work at the Southern Center. And along those lines, talking about this concept of correctional control. And so not just looking at incarceration rates, the rates at which people are placed in cages and jails and prisons, but looking at the rate at which people are under some level of supervision, whether it be by a parole officer or by a probation officer, just looking at the rates at which people have to report to someone else and the ways in which their freedoms are really truncated and their freedoms are really abbreviated and are far more narrow than people who are not under correctional control. And if you look at this graph right here, you can see the national rate at which people are under correctional control, which is both parole, probation, and then also incarcerated status, was about 1 in 31. This graph is about a couple years old. But Georgia, just looking at Georgia, not taking any other state, Georgia's rate is 1 in 13. So for every 13 individuals in the state of Georgia, at least one is under some form of correctional control. And this rate of correctional control is really a leader in the country. And so this high rate at which Georgians and Alabamans by extension are placed under correctional control, coupled with these race and class dynamics that we touched on earlier and will continue to look at going forward, again, is really at the forefront of the work that we do at the Southern Center. And so focusing in on the work of the impact litigation unit. And so just to take a step back as to, looking at what that term means, impact litigation is, those are lawsuits that really seek to challenge failures within our criminal legal system and to, ensure that we get court orders and improvements and substantial changes that ensure that people are treated more fairly in the system going forward, right? And so the Southern Center, for a long time, we primarily filed these class action civil rights lawsuits that really sought to, to challenge inhumane prison conditions and such, and we'll delve into that a little bit more later on. And the sole goal, again, was to get what we call injunctive relief, relief that would change systems, improve policies, and such to ensure that people's lives are protected. But more recently, we have been incorporating both those injunctive demands and along with money damages cases, because we think that both forms of relief really do work together to improve the lives of people ensnared in this system. And within our impact work, we have a variety of practice areas that fall into our impact, that fall under the impact umbrella. And so I'm going to talk briefly about each of those areas just to kind of give you a sense of the kind of work that we do within our impact, within the impact realm. And so the first is challenging unlawful policing. As you saw with one of the earlier graphs that showed the statistics by which, show this huge disparity by which people of color are policed and stopped and cited and such. These problems really start at the front end, the moment people interact with police. And so we try to intervene as much as we can at that front end because it is driving the mass caging that we see across Georgia and across Alabama. And so this picture right here shows, I'm sorry, sweetie, can you go ahead? I'll be with you in a second. That was one of my co-counsel trying to, okay, go ahead, you're done. I'm sorry, guys. It's speaking of lawyering from home, it involves a lot of that. But this here is a picture of the majority of people who were arrested at a party in Cartersville, Georgia, which is about 50 minutes or so north of Atlanta. And these young people, there are about 70 or so total. Honey, you're done. Okay. I'll help you later. All right. Go ahead. They were attending this party in Northwest Georgia, and the police were yes. So they were attending this party, and police were called to the general area where this party was happening because there were reports of gunshots in the area. Not specific to this house where this party was happening, which, by the way, was on New Year's Eve, and it was a birthday party for a young woman who had just turned 21, but the police were called to the general area. And upon driving to the area where this party was happening, they noticed 4 young Black men standing outside of this house where the party was occurring. And the police officers claimed that they smelled marijuana. And so they entered the house without a warrant and without consent, and they immediately detained everyone who was inside the house. Several hours later, a search warrant was obtained, and after the search was concluded, a combined amount of less than an ounce of marijuana was found in the home, which in Georgia is a misdemeanor. In various jurisdictions is no crime at all. And everyone who you see pictured here, in addition to about 20 or so other people, was arrested and charged with misdemeanor marijuana possession and taken to jail. And they remained in jail for about 1 to 6 days and had to post bond to get out. And when they were released from jail, booking photos like the ones that you see here were plastered across social media and across the internet. And these young people came to be called the Cartersville 70. And a number of people were released from jail to find out that they had lost their jobs because their employers had learned about these arrests. Some of these young folks were in the military and saw their security clearances affected by this arrest. And some just, experienced social stigma to the highest degrees and a lot of just harassment and humiliation because of their arrest in this matter. And I have to say that this case was really a check for me because I'm frankly used to working with people who have been in prison for decades. And upon learning about this situation, I I was like, these young people were arrested, primarily Black and brown people, and sat in jail for 1, maybe 2 days, over some pot, which again, in a number of places is not a crime. And frankly, my first reaction was to really to underestimate and really to undervalue the trauma of having this interaction with police and being put in jail. And I think maybe perhaps part of it was maybe I become a little bit numb to the fact that Black and brown people are far more likely to be stopped, cited, and arrested for crimes like these. And it just didn't shock me. But in talking with person after person who was arrested, they were shocked. And they did not have the expectation for themselves that they would ever interact with police in this way. And the fact that people, would assume that they would, and would call them names and ridicule them really harmed them and really traumatized them, because they did not see being in a jail cell as part of their future. And, it was really devastating to them, and really made them rethink their relationships with law enforcement. And so, to make a long story short, eventually the prosecutor, actually 12 days after their arrest, the prosecutor dropped the charges, but the booking photos remained, and people continue to live with the effects of this really wrongful arrest and detention and search. And so we filed a lawsuit on behalf of dozens of people who attended that party, arguing that the police violated people's Fourth Amendment rights, violated their due process of rights, and that this was an unlawful mass detention, search, and arrest that never should have happened. And frankly, we have to wonder whether this would have happened had this party looked very different, right? If that photo array I showed you had very different faces on it, with people of different races, whether we would even be talking about it right now. And so this lawsuit continues to this day. We are in the midst of depositions, which we are taking remotely. And we are hoping for policy changes that no longer allow police to enter homes without warrants based solely on the smell of marijuana, and some form of damages that will help people heal from this traumatic event. Another part of our work that I want to touch on is our efforts to really end financial incentives within our criminal legal system. Before I started doing this work, I never would have thought that courts had a financial interest in keeping people in jail, or that jails would have had a financial interest in people being locked up. But it doesn't take long in doing this work to realize that money is often driving whether people go home or go to a jail cell in many places. And I just want to give you, just a sense of how this plays out. In Georgia, we have a for-profit probation system. And what I mean by that are companies whose profits are derived from the number of people who are on probation and the length of time that people are on probation. And so in Georgia, we have a few dozen of these companies, and they range in size from small mom and pop operations to big, multi-state corporations. And in our state, they supervise about 80% of the people who are on misdemeanor probation. And they take in about $10 million in quarterly collections every year. And the thing to note about being placed on misdemeanor probation in Georgia is that oftentimes you're not placed on probation in a misdemeanor context based on the severity of your crime. Oftentimes you are placed on probation for no other reason than your inability to pay your fines on the day of court. And so what we often see are that two people with the exact same charge can walk into court charged with driving with a suspended license, for example, or driving without a license, I'm sorry. And at sentencing, if they plead guilty, they will go up to a judge, and the judge will ask them if they can pay their fine on the day of court. The person who can pay their fine of, say, $1,000 pays their fine and then leaves court that day. The person who cannot afford to pay their fine is then placed on probation with one of these for-profit companies. In addition to paying their fine, they also have to pay the supervision fees that come with being on probation, that are monthly in the case of these Georgia companies. And so at the end of the day, people who could not afford to pay their fines, people who are not of means, end up paying more than people who are. And then coupled with that is this issue of being under correctional control. We're not only paying more, but then you are subject to arrest if you violate various conditions of probation. And so we've seen we've seen these for-profit companies use a number of different tactics to extract money from people. And just to be clear, again, they make the amount of money and profits that they make largely depends on the number of people who are on probation, and they need to ensure that they stay on probation for as long as possible so that they can collect supervision fees. And so I've seen in one particular instance a probation company that unlawfully extended people's sentences. And what I mean by that is that a judge would sentence a defendant to 12 months on probation, but when they would go and meet with their probation officer, the length of time had been extended by a year to 24 months. And I saw this with one woman's case, and I just thought it was a clerical error. I really just thought that there was some error in translation, and we just need to go back to the court, with a motion for clarification of sentence to deal with this. And it became clear during the court hearing that we had to have about this, that this was in no way a mistake, that the probation office had intentionally changed this woman's sentence under the guise of being benevolent, frankly. They wanted to give her more time to pay off her fines. And so by extending her sentence, she would have more time to pay off her fines and meet her financial obligations, ignoring the fact that she would also have to pay more in probation supervision fees, so it wouldn't make sense so that this benevolent nature really was not playing out. And thankfully, they changed her sentence the court changed her sentence in this matter. But we've seen this play out, in Alabama, across Georgia, where companies are unlawfully doing this. And if you don't have a lawyer to defend you in these cases, oftentimes these practices go unchallenged. Another practice that we saw was in Southwest Georgia, close to the Florida border. And it was in a small community, or rather in two communities, one called Pelham and one called Bainbridge, Georgia. And I'll just kind of explain Mr. Edwards' case, because I think that gives you a good sense of how this plays out. Mr. Edwards, who is seated in this chair right here, he was cited for the grave offense of burning leaves in his yard. And so he had to appear in the local municipal court. And when he appeared in court, he was asked if he could pay his fine that day, which he could not. His sole source of income was Social Security benefits. And so for no other reason than that, he was placed on probation. He was sent to the back of the courthouse to meet with a probation officer, and the probation officer told him that he would not be able to leave court that day unless he made a down payment on his fines. And if he was not able to make a down payment on his fines by the end of the day, he would be taken to jail. And so the probation officers, you have to give it to them. They hand you a phone and they just tell you to start making calls and to find someone who can pay off the fines for you, or at least a down payment of it. Mr. Edwards could not find someone, and so he was taken to jail, where he remained for several days. There is very little about his experience that is legal, but this practice was able to proliferate, again, because people often did not have lawyers in court, and people really felt powerless by this. And so we filed a lawsuit on behalf of Mr. Edwards and a group of people in a class action challenging this practice against the Red Hills Community Probation. But we also called out the local police, right? Without whom the probation company wouldn't have been able to take people into custody, let alone threaten people with jail. And thankfully, that practice not only ended, but the probation company also ended. It shut its doors as a result of this lawsuit. And Mr. Edwards and several other plaintiffs were thankfully able to get some compensation, some damages for their devastating experiences. Now, before I go on, I see there's some things in the chat. Okay, so yes, there is a lot of talk about disenfranchisement and such. And here in Georgia, you have the right to vote unless you're under some form of correctional control. And so that includes both jail, prison, probation, and parole. And so once you're done with correctional control, then you should be able to vote. But there is some debate about whether people who have paid off their fines or not in certain instances, not here in Georgia, but as we see in Florida, for example, right? Does the issue of you're not being able to pay off your fines affect your right to vote? And unfortunately, we saw a really bad decision along those lines in Florida, and it seems to be an outstanding issue in various places. But thankfully here in Georgia, we do not have that issue, although there are some murky waters as to what, fines and fees and things of that nature. In Alabama, Alabama's disenfranchisement law is broader than Georgia, and so there's still this issue of crimes of moral turpitude and and problems with lifetime disenfranchisement. But right off the top of my head, I can't recall the rates at which people are being disenfranchised, but at this moment right now where election results really matter. I mean, they matter every election, but right now, there is very much a concerted effort to get out the votes. There's very much a concern that this scarlet letter of any kind of involvement within the criminal legal system can impact your right to vote. And just the one last example I want to give of how financial incentives play out in the criminal legal system is with respect to things that really, once people are done with their sentences and these criminal fines and these criminal, these debt obligations to the courts still live with them. And so I just want to give the example of Mr. Brewer, who is pictured right here, who was charged with a traffic offense in 2014 and received a fine for, honey, I need you to, and received a fine for this traffic citation. And a few years later, he applied for utility services with the city of LaGrange, which is about a little over an hour southwest of Atlanta. And the city of LaGrange is a municipal court, a municipality that provides utility services. So instead of going to PG&E, as I did when I was younger, you would go to the city of LaGrange, and they will provide your water, electricity, gas, and other essential services. But they had a condition, and the condition was that you could not get services, or rather they had the discretion to deny you services outright if you owed back municipal court fines. And so people with municipal court debts were often facing the prospect of getting no utility services at all, or the city would allow them to get services, but condition access to those services from then on the monthly payment of these municipal court fines. And so pictured here is Mr. Brewer, for example, who, as you can tell, as is very obvious from his picture, had medical needs and required electricity to breathe. And he was often threatened with disconnection of his utility services, in part because of these debts. And thankfully, after years of litigation, we are on the verge, we hope, of resolving this matter, and the city has already agreed to end this practice. But it's a practice that largely fell on the shoulders of the city's Black and Brown communities. Again, going back to the disproportionate rates at which Black and Brown people are cited and pulled over and stopped by police, that led to predominantly Black and Brown groups of people in the LaGrange Municipal Court. And of course, that leads to a predominantly Black and Brown set of people who are being impacted by this rule that conditioned access to very basic life necessities on the payment of municipal court fines. And so I'm aware and mindful of time, and so I want to be sure to leave time for questions, but I just want to talk about a few other areas of our work. I mentioned briefly our prison and jail conditions work a little bit earlier on, and over the past several decades, we've been working on prison and jail conditions of a variety of fronts, whether it's medical care, violence between incarcerated people, overall conditions, solitary confinement. But we've really seen, the state of Georgia, at least, really responding to problems with violence and problems with gang activity with solitary confinement, which is where people are locked in their cells around the clock for days, weeks, and months on end without really receiving a meaningful opportunity to leave those cells. And so I just want to talk to you about a couple of those cases, just to kind of give you a sense of what they look like. This is a man who was in the special management unit, the SMU, which is in a prison that people kind of colloquially refer to as Jackson, which also houses the state's death row in Middle Georgia. And he was in this, this SMU unit, which is really one of the most draconian solitary confinement units in the country, or at least it was at the time that we filed a lawsuit. And every single aspect of a person's life occurred in a cage, right? And so if people weren't in their cells, which were about the size of a parking space, then they were in quote unquote learning modules where they would get some type of rehabilitative or vocational programming, which would occur in a cage. And then they would go outside, and which is where this gentleman is right here, and be in another cage, and that would be their recreation time. And it was really difficult, if not impossible, to get out of these conditions. And it was so difficult that people remained in this caged environment for years on end, with many maxing out their sentences and going straight from being in a cage 24/7 to going home, because they were never able to get out of this system before their sentences expired. And this is a picture, and I'm sorry, y'all, I probably should have warned you. This is a picture of a person who was in his cell in the SMU, and you can kind of see the conditions behind him. This picture was taken during an expert's inspection of the prison. And this is a man who is showing that he recently tried to harm himself, or actually did harm himself, because of the draconian level of isolation in this prison. And this is someone who did this, I think, the day before the expert came. And usually with these types of, usually when prisons know that people are coming to look and inspect their places, they really, honey, I need you. Okay, I'm sorry, I'll deal with that after I'm done. Usually the prisons try to clean up a little bit and really try to, put on, a good front of doing all that they can to protect people. But even in this instance, they couldn't hide the devastation of their practices from an expert and from lawyers from our office. And so just as a, kind of to tie that up, we filed a lawsuit against the prison, or rather prison officials, on behalf of a number of people who were in the SMU, and we reached a settlement agreement that allowed for people to get more meaningful time outside of their cells. Another example is really one that's closer to home, the South Fulton Jail. Atlanta, for those who don't know, is located in Fulton County, and in the southern part of the county, there is a jail that holds women, in large part because the main jail is too overcrowded. And this is a jail that for a long time, and frankly, we're still monitoring the situation now, where women who present with psychiatric disabilities, mental health issues, and mental illnesses were categorically placed in isolation, categorically placed in prolonged isolation for days, weeks, and months at a time. And in those conditions, their condition deteriorated. They decompensated because they were not allowed out of their cells. And study upon study has really found that prolonged isolation of this sort really just exacerbates existing mental health conditions. And so we filed a lawsuit challenging those conditions. And right now, the jail is under a preliminary injunction to make some improvements to the amount of time that women get out of their cells. And I'm sorry, just a quick note to kind of bring some joy and positivity to what we do. In addition to challenging, all of these conditions that we just talked about, there is this back end effort to really address the sentences that people are receiving within the state of Georgia. And for a long time, Georgia mandated a life sentence for a second drug conviction, possession with intent, or sale of a controlled substance. And that went from being mandatory to being discretionary. But those sentences weren't life without parole sentences for people. And so we've done a lot of work to address the harms of that, and to really try to get people out, to tell courts that this is not who we are, and people should be allowed people should be allowed out and experience freedom. And when we started doing this work, we learned about one particular person who had served, over 2 decades for 3 grams of cocaine. And we thought that he was kind of an anomaly. But when we started digging more and more, we realized that there's a small community of people serving life without parole sentences for drugs. And every single one of them was Black. Not one of them was a white person. And so we've kind of gone forward and represented as many people as we can, both who are serving these life without parole sentences, but also people who are serving terms of year sentences, life equivalents, like 30 years without parole, 60 years without parole, 70 years without parole. And to date, when we started doing this work about 5 years ago, there were about 15 people who were serving life without parole sentences for non-trafficking drug offenses. And currently there are 3, in large part because of the work that we have been doing. So just to kind of move on, thank you, Anna, for that comment. I want to bring us to where we are right now. And again, I'll try to be quick because I understand that we want to talk more amongst us. We have been doing all of this work, for quite a while, and this is what I've spent a lot of my time, the last 10 years of my time at the Southern Center doing. And, we're doing all this work, and it has continued on through COVID, and it has become more dire and more desperate in light of the COVID pandemic. And I'm sure the reasons for that are pretty plain. All the ways in which we are protecting ourselves during this pandemic are just not possible, at least in a free way, a meaningful way for people who are incarcerated and in cages, across the country. And so people on the inside cannot choose to socially distance. That is not within their power, and they largely have to rely on prison officials to make that happen. And oftentimes they don't. And the people who we talk with right now do not have free and liberal access to soap, hand sanitizer, or even masks. Those are things that they have to rely on prison officials to provide. And access to testing is just not something that is free and robust. And as we know from being out here, in the free world, quote unquote, testing has been kind of scarce at times. And so just imagine what it's like when you're on the inside, where you have to meet an even higher threshold to even get some meaningful access to care. And so we have spent the last 6 months really trying to fight these conditions, frankly, from homes. The prison systems in both Georgia and Alabama have suspended visitation. It's been like that since March. And so we have been having to talk with people by phone to gather their stories and gather their experiences, and so that we can so that we can argue for their release before the parole board, push the prison system to protect people, and do whatever we can to really raise awareness and even file lawsuits. And so I just kind of want to talk a little bit about what this has looked like, at least on the Georgia front. And so I'm sorry, y'all, I couldn't capture the entire map here of the COVID stats that are in the Georgia Department of Corrections. But as you can see, and putting all of this very offensive language about offenders and such aside, almost 2,000 people had tested positive for COVID in the Georgia Department of Corrections as of yesterday. And there were 73 people who had died. And just a note about the deaths, I was in a meeting with prison advocates from across the South a couple of days ago, and one person raised a concern that many of us have, is that these death counts are not often accurate, and that they might be undercounting the number of people who are testing positive, who have COVID. And it might be because they don't know if that person had COVID, because not everyone's getting access to testing. We don't know, but at least what the Georgia Department of Corrections is saying is that 73 people had passed away from COVID as of yesterday. And just as a matter of comparison, I checked California's numbers, and according to the California Department of Corrections and Rehabilitation, there were 70 people who had died from COVID. And just to kind of put that even further context, there are about 49,000 people who are incarcerated in prisons in Georgia. As I'm sure some of you know, there are over 90,000 people who are incarcerated in California. And the number of deaths are about comparable, with Georgia slightly exceeding California's numbers. And so what this has created within the Georgia Department of Corrections, what COVID has done is just really taken a system that was already failing to meet the needs of incarcerated people and making it substantially worse. And that's for a number of reasons. One is, as you saw with those stats, right? I didn't even go over the stats for staff who have contracted this disease, but guards are just not coming to work the way that they used to. That might be in part because they recognize that prisons are not a good place to be during this pandemic. And it could also be because they're getting sick, or their family members are getting sick, right? And so people are just not coming to work the way that they have before, which really limits and restricts people's access to laundry. It restricts their access to edible food. It restricts their access to outside time. And so what we've been hearing from people is that they haven't seen a guard, they can go 24 hours without seeing a guard. And people are languishing in their cells without any time outside of them. And they are getting the most substandard food, spoiled food, for example, and they're not getting clean clothes, like the very bare necessities they are doing without. And what that has led to in some circumstances is kind of what you see in these, these fuzzy pictures here. These are pictures from Ware State Prison, which is in southeast Georgia. And as you can tell from the headline, people refer to it as a riot, where people, incarcerated people, really created this disturbance, and there was a fire and everything. And it's in large part because their needs were not being met. And on the night that this happened, where this fire was and such, there were 6 guards on duty. And this is for a prison where there are 1,500 people. And so it had completely broken down, and people were in a desperate situation. And we have seen riots occur in a couple of other prisons in Georgia during this pandemic alone, in the last 6 months. And this type of rioting and disturbance and protest is just not something that we saw in the days before, or in the times before COVID became a daily reality for us. And so the situation has become incredibly desperate on the inside. And it's also in part because people are just not receiving the protections that they should, as I mentioned before. This is a portion of a declaration, a statement that a detained person, just south of us in Atlanta here, a detained person in Clayton County, they signed this statement about the care they were receiving, or the lack of care they're receiving in the Clayton County Jail. And as you can see in point number 8, I believe, they were talking about access to masks, and how this person made a mask out of a bed sheet because they were not given one. We spoke with other people who were making masks out of underwear and other parts of torn clothing because they just were not provided with N95 masks or anything of that, anything remotely approaching that type of protection. So we have been working on a number of different fronts to address this situation. We have done individual advocacy on behalf of, people who are in their 60s and 70s who have a host of medical conditions, and for whom being in prison is just not safe at this time. I mean, they arguably weren't safe before COVID because of a number of failures before COVID, but they are really not safe right now. And so we've written to the parole board. We've done what we can to get people out. And I'll talk a little bit about some of our successes on that end. But we really need a far more aggressive approach to decarcerate prisons and jails during this time if we're going to have any kind of meaningful impact. Another outgrowth of this COVID crisis is the budget piece, right? About midway through the pandemic, in June or July or what have you, the state of Georgia announced that people, that state agencies would have to make really severe cuts to their budgets to deal with the budget shortfall from COVID and businesses being closed and, most aspects of life in the state being closed. And unfortunately, as is often the case when budget cuts start to be discussed, the public defender system was very much in danger of losing a substantial part of its budget because it is one of these state agencies that is under the purview of Georgia's governor. And thankfully, our office teamed with a number of allies across the state to really try to save one particular piece of the public defender agency that was in danger, which was the appellate division of our state agency. And so I highlight this because I think during this crisis, it's very easy to talk about not easy, but I think you hear what I'm saying. I think there's some attention being paid to the conditions and the health crisis, but there is this budget crisis, and this budget crisis often hits people who are also ensnared in the criminal legal system, right? And so just to kind of circle back with this instance, with the appellate division and the public defender agency, we were able to convince lawmakers, us along with our allies, were able to convince lawmakers not to make the devastating cuts they were planning to make. We then had to focus our sights on the public defender agency that wanted to make the cuts anyway. And thankfully they didn't after a lot of advocacy and such, but there's still a lot of work that needs to be done to kind of make sure that that portion of the agency is doing all the work that it can. And so I just want to kind of wrap this up in talking about, our work to get people out during this time. And earlier, we briefly mentioned, a really courageous man who I met as an intern who had been in jail for 13 months for the grave offense of loitering. And thankfully, he was released from jail after we found him there when I was, golly, that was almost 20 years ago. But unfortunately, he was rearrested for selling $40 worth of cocaine in the same jurisdiction. And when he went to court for this offense, the court system really took the opportunity to give him an incredibly lengthy sentence. And so for that offense alone, he received a sentence of 30 years with the first 20 years to serve in prison without parole. And so over the years, I stayed in touch with him as an investigator. And then, when I came back as an attorney, and there wasn't much that we could do because his sentence was without parole. The parole board wouldn't touch his sentence, and we were not able to really work with the local power structure in the county where he was prosecuted to get him released. But we continued to fight for him, and we took advantage of, not so much took advantage, we asked the parole board to exercise its authority under the state constitution to release him, because by this time he was 62, had cancer, and had a number of other health concerns. And finally, the parole board released him in May of this year. And I'm just so grateful for this, but I'm still incensed that it took 15 years for him to get out. And so this is us on the day that he was released, back in his hometown, which he has left. And he is an example of at least one person who we've been able to get out during this pandemic. Another example is this man named Samuel Smart, who's on the right side of this screen here, who was sentenced to life without parole for possession of cocaine with intent to distribute in the late 90s, and really did all the work, really made it so easy for us to advocate to the prosecutor, because he somehow spent about 2 decades in prison without a single disciplinary report within the prison system, which is astonishing in any regard, but in large part it's incredible because the parole board was never going to review his sentence. And so he really had no incentive to follow the rules and do, and be, compliant with everything, because it really didn't matter with respect to his sentence. But he was himself, and he wasn't going to, change who he was, even though the deck was very much stacked against him. And thankfully, we were able to convince a prosecutor in the county where he was convicted to not only release him, but to dismiss the underlying charge. And so this is him, in a picture with his longtime partner who picked him up on the day of his release. These two men are among maybe close to 10 people who we've been able to get out. But in a prison system where there are 49,000 people and there are thousands of people with serious medical needs, many who are very much in that CDC identified age range of being medically vulnerable, there is just so much work to do. And we've seen a number of our clients not go home, and we've seen people die during this time. And so we very much, we hold and appreciate the Samuel Smarts and the Samuel Moores who have been getting out, while we mourn for the loss of many people who have died on the inside. One thing that is really, really crucial to our work, and I've seen this question pop up a couple of times in the chat, and I'm so excited to discuss opportunities to work with us. Really, we cannot do the work that we do without interns. We are a small office, and one thing I should have said at the outset is that we're an office of about 30 people, about 15, 16 or so lawyers, and about 6 or 7 investigators, and then administrative staff who are so vital, and people who really help us pay our bills, our development arm of our office. But we're a small office, and the needs across Georgia and Alabama are so great. And we get far more requests for help than we can fulfill because we're small and we don't have the capacity to help everyone who reaches out for us, which is why we lean so heavily on interns. I was an intern when I first came to the Southern Center, as was mentioned earlier, and a number of the people who are in our office today as full-time lawyers were previously interns. And so the intern experience is just so vital to what we do. And we really try to give interns meaningful experiences within our office. And I'll just kind of give you a sense of a few things that that interns get to do when they come to work with us. Aside from legal research and writing, which is really kind of the bedrock of an internship experience as a 1L or 2L, interns get to help draft motions and portions of briefs. They help to locate and interview witnesses. They visit and interview clients. And this past summer, we had a fully remote summer internship program in light of COVID, and our interns really just adapted, and they were doing tons of phone interviews and gathering people's experiences and gathering the information that they needed, to advocate for people. Our interns also go out and monitor court proceedings, which is to go out and sit in the LaGrange Municipal Court, for example, and see how people are treated in that context. They also advocate before the Alabama Parole Board on behalf of people who are seeking parole in that state. Alabama, unlike Georgia, actually has parole hearings, and you don't need to be an attorney to appear at those hearings. And so, and frankly, students have had much better luck and success on the parole front than attorneys have. And so we frequently, really all the time, we send students to advocate on behalf of people seeking parole in Alabama. And the parole board, up until very recently, when there was an unfortunate change made to their membership, has really responded well and released a lot of our clients. And then finally, we really treat interns like members of our teams, and so they attend our meetings and are really engrossed and engulfed in the work that we do during their time with us. And so I'm going to put, once I'm done talking, I'm going to put the link to our the page that more fully describes our internship program, and it includes an embedded link to our application that we now have online for anyone who's interested. But we take students after their 1L year, after their 2L year, during the summer, full-time, and then we also have a fall program and a spring program. And I'm not sure about how things work at UC Irvine, but we've worked with students across the country who have been able to come down to Georgia during the fall and spring and get academic credit, for example. And now with things kind of being remote for the foreseeable future, it almost doesn't matter where you are. We had students who were in California who advocated on behalf of people before the parole board this past summer. And so I'll put that link so you guys can check it out. I have supervised, or at least co-coordinated, the internship at the Southern Center for the last 10 years. I'm kind of transitioning out of that role, but I know enough about the program to be able to speak with anybody who is interested in learning more about it. And so I will put the link to the SCHR internship page / application in the chat. All right. And this is my contact information. My email is here and my phone number is here. And I'm so sorry I went so far over time, but I'm hoping that if folks have questions, that you'll be willing to share them now. So thank you so much for indulging me and listening to me wax on and on and on. And I see there's a number of questions here that I have not reached, so I'm going to try to go through them now. So there's one question about advice for people who are interested in this area of the work, particularly for 1Ls. So I think that I'm not sure of the clinical opportunities at UC Irvine, but I can say as a former law student myself that those were incredibly important. Any opportunity that gives you experience with working with people and perhaps advocating for them. It doesn't have to be as on point as doing this work at the Southern Center, right? I am very mindful that there is this underlying irony of doing work on behalf of people who cannot afford legal services and a nonprofit, and the incredible privilege that comes with doing that work. Not have to worry about receiving a high salary and such. And it's an area of work where you almost have to have some level of privilege to do it. And so obviously, relevant experience is very helpful when you're looking for this type of work, but I would not select yourself out of the pool if you don't have the direct experience. We've hired people who have done immigration work or who have just really excelled at being really good at customer service. We have also had interns who might not have interned at EJI, but can tell me a ton of stories and reflect on their experiences of having been through the system or who have had family members who have. And so really finding, really just whatever your experience is, whatever your passions are, finding some way to connect it to the work is really important, and being able to articulate what your passion is. Let's see. Oh dear, yes, these alternatives to cash bail. And yeah, what was the appeal of my working for a public interest organization who funds us? So very quick on that front, on the funding question, we do not receive any state funds. We entirely subsist off of donations from individuals and grants from foundations that care about our work and want to see it continue. In terms of, these alternatives to cash bail and such, one thing that we have really started talking about is the need to ensure that whatever our quote unquote reforms are, that they are not extending the life of the criminal legal system and not extending the reach and, and the pull of these various entities that wish to see as many people as possible ensnared within the system. And so it is hard, particularly when you're, if I'm a person who's in jail and I have the prospect of being on an electronic monitor, then I probably will take that because I need to get home to my kids who you have seen repeatedly in this Zoom screen. But I think that we do need to be mindful about that and about the reach of these quote unquote alternatives that do nothing more than really just extend the arms of the criminal legal system and ensnare people in those systems for as long as possible. So what motivated me to go the impact litigation route versus the public defender route? I think that my time at the Southern Center as an intern really solidified in me the desire to really work on this impact front. And I mean, I really love and I appreciate public defenders. I think they frankly do work that, it's so heroic, and the way that our systems too often underfund them and understaff them is really criminal to me. But I think I chose this route because I wanted to, really look at systems more globally, and figure out ways to not so much fix them, because I think there are very valid arguments that the system is not broken, that it's working as designed, but really trying to transform them. And I think as is hopefully evident from these experiences with Mr. Moore and some of our clients who have been resentenced, that I've really sought out ways to do individual advocacy. And so that I'm not hopefully I'm not like this one trick pony who only does, Section 1983 cases, but that I'm really trying to complement that with individual representation. And I think that's just one thing that I would share across the board, is that I think it's really great to develop an expertise. I also think it's really important that we try as many things as possible, because frankly, our clients are not one-dimensional people. They have a range of they have a range of experiences and a range of needs that can't be met with just one tool. And so I would really encourage folks to really look for opportunities that allow you to really stretch yourselves and not pigeonhole yourselves in one thing. So I think that's it. I recognize it's 4 o'clock my time and 1 o'clock there. And so what I'll do is I'll pull up the link actually, I'll just do it right now. I'm going to stop sharing my screen, and I'm going to pull up the link to our program, or to our internship program, so that folks can check that out, if that's okay. But while I do that, I just want to say thank you so much for having me. I really appreciate the invitation to be with you guys. And I know I'm not in California right now, but it means something special to me when I can speak to folks who are. And so really take care of yourselves. You have my contact information here. I would love to hear from you, and thank you. Take good care and be very safe.
Thank you for an extraordinary presentation. I'm sure you'll be hearing from some of our students. Bless you for the work you're doing.
Thank you so much, Henry. You take really good care. And yes, please reach out. And yes, and thank you for indulging my children who they see a Zoom screen and they run straight to it. So thank you so much, and take care, everybody.
They're our future. Take care.
All right, bye-bye.
Bye.